Right. So we will move on to item 21. The Council's submission on the Resource Management Consenting and Other System Changes Amendment Bill. Good afternoon.
Good afternoon now.
1 minute. Yeah.
By 1 minute. Thanks. We take the council report as read. However, we do want to highlight and talk to a late amendment made to the draft submission, which is attachment A, which was circulated to you on Monday. The draft submission we're therefore seeking approval of today has been amended from the draft that was published with the agenda. The amendment, specifically the new paragraph 5, has been made to address our concerns regarding the proposed process to withdraw parts of the MDRS that are undecided. These proposed provisions do not provide for a cost-effective and simple means to withdraw these undecided parts. I'll pass over to Ike, who's going to talk this through in more detail.
Thank you, Helena. As Helena said, we've received updated advice on the option that the bill puts forward for having an opt-out for the MDRS, specifically for the scenario where council is yet to decide on applying the MDRS, which is obviously our scenario. We had originally thought that it was an approach whereby we would have to evaluate the current NPSUD in terms of our conformance with policy 3, right to the minister, and we can withdraw, and then that's that. Unfortunately, there is an additional clause that is separate to the clause that addresses that option, which states that should a council do that in terms of going through the opt-out of the matters that are yet to be decided, then we will also have to go through the process of a new streamlined planning process to give effect to the new National Policy Statement on Urban Development. Put simply, what that means then is that the two options that are only available for Plan Change 14 are to either decide on what is outstanding for Plan Change 14, as in the areas beyond Policy 3, or to do a new plan change process to give effect to the new NPSUD, which would begin next year. So that's the position in the bill, and so that's what we have targeted in terms of the amendment that Helena mentioned in paragraph 5, highlighting the, in our opinion, highly inefficient process that leads to considering the infancy of Plan Change 14 decision.
Okay, Councillor Templeton.
Thanks for that. Completely agree with that being included. Thank you for picking that up. A separate topic though. On some issues we've had a sort of a decline in the past over looking at the ability for councils who have highly flammable pine plantations close to urban areas, and whether we could include something in here that discusses that. This isn't probably directly, I'm told, in this one, but indicating our preference for the ability for councils to do that, noting that the current proposed process and our submission says, yes, extend consents, but actually if we can extend them, and we're saying we want to be able to do that, does that mean we have a problem with limiting pine plantations near our urban areas? Does that all make sense?
Yeah, so if I can, we have got a national environmental standard for commercial forestry, the NESCF, which was very recently updated. That directs as a permitted standard that there has to be at least 30 metre separation of any afforestation, so new planting of forest, from an urban area. So that's the baseline, if you will. The changes to the NES, used to be the NSPF, but NESCF, now mean that a district plan can also have controls that are either more restrictive or more enabling than the baseline that the NES sets. And so that ability is still given to us through the current legislative framework to the regulation of the RMA. So should we want to have additional controls, then we can do that. If somebody requires a separate plan change to do that, there's no other additional change that would be required through the submission, so it's unrelated in our opinion.
Yeah, but this is for that and that'll be great, and I think we should. But that's for new plantations. rather than the ability to make changes to existing plantations, existing land uses where potentially there has been a fire and then a desire for some in the community not to replant, which is not a new forest, it's just to replant it, and our ability to make those changes. Is that something that would go in here?
I guess our view is that it wouldn't necessarily fall into this submission. It may come through when we receive the National Direction Package, if it forms part of that later, well, relatively soon when that package comes through. But our preference would be that, or our advice would be that it doesn't form part of this submission.
We could give them a heads up though. I don't know. It's just something that's, Is it not appropriate for them to be adding those kind of things in this particular piece? No.
Yeah,
They could if they wanted to, or?
Our opinion is that the current framework allows for us to do that change. So if we feel that there is a change that's required in terms of those provisions, then we can do that change. But I mean, in terms of your point of existing forests, it's quite hard to take away that existing use right that exists there as it stands. And so if they're already existing there, then they have that existing use right. There may be some changes in terms of conditions that we can review in terms of performance that these forthcoming changes allow for. So we could utilise that in the future.
Okay. So just for whichever one is coming up next, we want the ability to be able to make those changes on conditions, and it might be that near urban we want to change it to a setback that is in line with new plantings, not in line with the existing conditions.
Yep.
Those kind of things. That'd be great.
Sorry, just in addition to that, we do have 2 new bills proposed to come in towards the end of the year, and that might be the more appropriate time to raise these types of issues, because you're talking about existing resource consents as well and existing use rights.
So might some of that come in through the Adaptation Act, because that's the hazard mitigation. It's not just sea level rise; it's other hazards.
It could, but also the new bills might be an opportunity there, because the previous bills were considering things like how to deal with existing use rights as well, which did include Climate Adaptation Act then.
And like Elena said, there's new direction for natural hazards as well, which may very well include something like wildfire risk.
Yeah.
And so we can put a submission on that basis.
Okay, thanks.
Yeah, thanks. I see in the bill that they talk about giving more permissive planning for inland ports and also wood processing. Given the decision that we've seen around the Portland site, have we looked at any sort of amendments that we feel might be beneficial to safeguarding the community around the environmental effects of inland port activity?
We haven't commented specifically on that in our submission, no.
Could we put something in? But my reading of the bill, and I don't know if this is the correct one, is that it refers to port authorities, but inland port activities, if it's not a port authority, can be just as damaging and disruptive as a port authority.
Yeah, I mean, we can come back if there's an amendment that you want specifically added to that. I guess staff can look at that.
Yeah. We also saw people fumigating logs, and I don't know if that would come under wood processing, but they didn't have a consent, so for methyl bromide fumigation of logs, which I assume is like a port sort of thing. So I just think it would be useful to put some concern. The other thing is that with the Portlink site, there's obviously a serious health and safety concern with the containers falling over. So that we don't seem to have any ability in our district plan to take a health and safety well-being approach to some of the things that we're considering. And I'm just wondering if this, again, looking at what's in here, is an opportunity to raise the need to be able to look at those sorts of things rather than just rely on WorkSafe, which the community kind of ring repeatedly, but doesn't seem to make any difference.
Yeah, so the health and safety is captured in the purpose of the Act and the RMA. And so through the ability to monitor the performance of consent holders that this change allows for in terms of those conditions of consent, in my view, would be able to better monitor those conditions of consent in light of giving effect to the health and safety of containers or whatever the case may be.
Sorry, but the question, I guess, is if you've got an existing activity that doesn't need a consent and it's causing a health and safety issue for the local community, do we have any powers to do anything about it?
Plan change. We have the ability, obviously, to make a plan change, and we are doing that for industrial activities as we speak.
But that doesn't give, if it's a health and safety issue, with due respect, like waiting, a couple of years, half a decade to do a plan change doesn't give the community much sense of safety or security.
Yeah, no, I think in terms of the industrial activities, the plan change is scheduled to come before you this year, so it's not a matter of delaying any further.
Okay.
There you've supported targeted amendments to compliance and enforcement provisions, which gives us more ability to act. So that's a comfort.
Yep.
I'm just thinking like number 21, where you talk about the significant, the changes in the RMA over the years have placed significant pressures on councils, and we're consistently shouldering the costs to implement piecemeal reforms. For example, it's anticipated the recent IPI process will cost upward of $7 million, not including staff time. Could we add these costs will need to be borne by our ratepayers at the bottom of that? I know it's obvious, and then also can we add that to 22 as well? That's regarding the issue with the NPSUD.
It's the ratepayers is included in that 22, but I'll add it to the 21 as well.
Yeah, just to call it out, I think. Because we are all trying to keep the rates increases down as low as we can. Are there any other questions? Can I call for a mover for the report? Councillor Harrison Hunt, and seconded by Councillor McClellan. Is there any discussion? All right, I'll put the motion. All those in favour say aye. Opposed? That's carried. Thank you very much.
Thank you.